Good evening. Welcome to Immigration Issues. I'm Ina Winston, and it's my pleasure to be here with you. And we have a special guest today, Elizabeth Tasek, who is an attorney and the Director of Operations for our organization. And it's a very special program we have lined up dealing with domestic violence survivors and legal remedies. So, most of you who watch the show regularly know that the Chicago Legal Clinic was established in 1982 by Ed Grossman and then Father Paprocki, now Bishop Paprocki, who were two classmates at DePaul Law School. When the steel mills on the southeast side closed, they saw the need for high-quality, low-cost legal services. And so they established a very small organization, which then grew organically to encompass many different areas of law. And so we kind of developed a sprawling footprint of law. We now are focusing in a different direction. We have a new executive director, and it's a transition period. We are primarily based downtown now, and we will be moving probably to an inner Cook County suburb. So it's a transition time, but we still want to hear from you, and we're still practicing law, and we're open for business.
Yes.
So,
very much so.
What's happening? Usually I tell you a little bit about an update about immigration issues, what's going on, and then we go to our topic, and so we'll do that tonight too. What's going on in immigration? Well, USCIS recently proposed fee increases. That's probably something that has the most immediate impact to our listeners. The fee increases are all over the map. Some are high, some are modest. And there are also fee reductions too. So the comment period for these mostly for the fee increases, it ends December 30th, so they will not take effect until sometime next year. And exactly what the increases and decreases will be remains to be seen. But right now, the proposed for an I-90 to replace your green card, it was $455 and it's going down to $415, which is a good thing. That's a 9% reduction for a very commonly used form. On the other hand, we see an I-130 has a modest increase. It's $535 now, and it's going up to $555. We do see an increase also for citizenships that is a whopping increase. Let me find that N400. It is really something else. Hold on, I gotta find it. N400, application for naturalization, it's $640 now plus the $85 for the biometrics, going up to $1,170 plus the biometric fee. That's an 83% increase. What is the message we are sending now? If you're not wealthy, don't become a citizen. Is that really the message we want to send? So keep your eye out if you are planning on becoming a citizen, or you're planning on filing a petition for someone, or adjusting, or getting a waiver for unlawful presence. You should keep your eye out for the changes. Unlawful presence, the provisional waivers that are adjudicated here in the United States before the person goes abroad to consular process, those also have a big increase. Currently, the fee is $630, going up to $960. That's a 52% increase. So that's probably something that affects people most immediately. Last time we were here, we talked about the fact that the DACA cases were heard by the Supreme Court. It didn't sound encouraging. We don't have a decision, but it didn't sound encouraging from the tone of the arguments. The major issue in that case was whether or not the Administrative Procedure Act applied. That is, not so much whether the president had the authority to terminate the act, but whether the termination was done for a rational, articulated reason. And the lower courts had said no, the reason given was a specious reason that was thought up after the fact to justify this decision, and the reason didn't make a lot of sense. The reason given was that there had been a negative decision in a case in Texas, but the negative decision was in a case that didn't really deal with DACA. It dealt with DAPA, which would have extended DACA-type benefits to the parents of DACA recipients. And then to compound the problem, the reasons articulated was that they had to rescind the DACA Act because of the risk of litigation, which really didn't make sense because, as one judge said, well, wait, you just swapped a case by people who are opposing DACA for one by people who want to keep DACA. So how did you minimize the risk of litigation? You didn't. So we're waiting to hear, and I have to say, I think that in the lower courts, the judges probably were swayed by the fact that there's 661,000 people approximately on DACA now, and those people are holding jobs. They're married. They have families. I have many DACA recipients. My former law student, who's now a lawyer, was on DACA. These are productive people who contribute to the American fabric. And the idea of rescinding it is just disgraceful, especially considering that the government actually invited these people to out themselves in order to get legal working permits. There's something really wrong with the idea of doing this. And of course, when challenged about it, our president immediately made a flat-out lie. He said that the DACA recipients, many of them are not angels. Well, you can't get DACA if you have a felony or a significant misdemeanor, which normally means one DUI in practical terms, or 3 non-significant minor misdemeanors. So that's just a flat-out lie to portray these people as criminals. So we'll see what happens here, and hope that if it doesn't turn out well, judicially at least, that there'll be some kind of a legislative fix, because you have over 661,000 people in need of some relief. Also, in a similar situation, TPS is being challenged, and that case is actually even harder because it says that the government doesn't have to articulate a reason for terminating TPS. So we'll see what happens with TPS, and you have people who have been here from 1998, after Hurricane Mitch, working hard every day, contributing to America's progress. So we'll see what happens with the TPS cases. Other cases, well, the situation in the immigration courts is so dire that the immigration judges wrote a letter to their own union. The problem is that these courts are not independent courts. The judges essentially are just employees of the Department of Justice. And as one judge put it in his letter, Judge Ashley Tabador, an immigration judge, and most of these people, they work very hard to make fair decisions within the confines of a very restrictive law. So these are not radical outliers. He said, well, these changes by the Attorney General were making the judges be prosecutors in judges' robes, and that's not their role. The changes by the Attorney General are that they've set up metrics for case completion and have instituted the no courtroom dark rule, meaning that cases are supposed to be heard all the time, which would leave no time to actually think about what you're doing or to research it. It's kind of pathetic when you think that an ordinary judge in small claims court has more chance to think over what the person is doing and to render a rational decision than an immigration judge who is making life and death decisions for individuals and sometimes families. There's something very wrong here. So, in addition, the Attorney General has certified a certain number of cases to himself and just simply changed the law, disregarded the decisions of the Immigration Court or the BIA, which is the appellate body, and decided on his own that the use of administrative closure of cases can no longer be done by judges. Administrative closure was a remedy where you're waiting for an outcome in another forum, and there's no real point in rushing the case ahead because the person may have an avenue to become documented through some other forum. So they would just put the case to the side and put it on an administrative docket. Or they would simply administratively close the case for a person where there's really no reason to deport the person except that they're overstayers who were brought here as a child and they've lived exemplary lives. So they would just administratively close the case. Well, there's no more administrative closure. It's also much harder to get continuances in order to obtain counsel. And the courts, now judges are restricted from terminating cases. For example, I had a case where the people came into the United States, they were inspected, they were put in proceedings as a result of an asylum case, and they now can adjust on an immediate relative petition by their U.S. citizen adult daughter. And previous to these rules, the case would have been terminated and the person would have gone ahead and been able to adjust before USCIS. They have an approved I-130 for each person. Now we can't do that. We have to spend more judicial time adjusting in court, thus increasing the burden on the judges even more. So there are many changes. Asylum previously was available for victims of domestic violence and gang violence where governments would not protect or prosecute the wrongdoers. That is no longer a basis for asylum, which is really tragic. So we see many changes that are very disturbing and quite unfair to the litigants. Other than that, we of course have the Wait in Mexico protocols for asylum seekers, and waiting in Mexico is dangerous. I mean, because tent courts were set up in Nuevo Laredo and in Matamoros, both of which were designated by the U.S. Department with a level 4 do not travel warning due to crime and kidnapping. So it's very disturbing when people who have legitimate asylum cases essentially are told, go away, our doors are shut. That is a stain on the integrity of the American immigration system. Other than that, we have a memo on conditional bars to good moral character during the statutory period for naturalization. So in practical terms, I would say to people, if you're going to be naturalized, bring all your dispositions from any criminal case and from even minor traffic cases to your attorney so that these things can be disclosed.
It's probably a good time to bring up the cannabis.
That's a good time, that's right. The cannabis issue is a timely issue to bring up. Why don't let me introduce you. I think people should know you. You are an outstanding attorney who has devoted a life to helping domestic violence survivors, and you're knowledgeable in other areas too. So tell us a little bit about yourself, okay, and then let's go into the cannabis.
And then we'll talk about an area where I'm not super knowledgeable. But okay. So my name is Liz Potacek, and I am an attorney at the Chicago Legal Clinic. I have been a full-time staff member at the agency since 2016. Prior to that, I worked for 5 years at what was previously called the Domestic Violence Legal Clinic and is now called Ascend Justice. Their mission has expanded, so they do both domestic violence work and they represent people who are dealing with DCFS procedures. But so I spent a lot of my time looking at how the domestic violence court, specifically at 555 West Harrison, treats families who are dealing with domestic violence. And I came over to CLC to get some experience doing full family law litigation because I had had 5 years of just doing orders of protection and I wanted to expand what the kind of work that I did. I had interned at CLC throughout law school, so actually that was this is the agency where I decided that I wanted to be a direct service legal aid lawyer. So it was also an opportunity to come back to the place where they had a culture that I really liked. And since 2016, I have moved from staff attorney to directing our domestic violence program to most recently becoming the director of operations. So I am looking at how to navigate us through this period of transition. I think that we're trying to look at trends in where our clients are located and what their needs are, and design our agency's footprint, both geographically and in terms of the programs that we use, to reflect the communities that we serve better. So it's only been a couple of weeks. It's been a wild ride. But I am very grateful that in the past year, with all the changes that have taken place, I've come into contact with more of our attorneys. I don't know. I feel like the past 10 minutes have just sort of been me like blown away by the amount of information that you are assimilating for your viewers every time that we have
We're glad to do it. The clinic is a very caring organization. We do take care of our clients, and we care about the legal matters, but we care about the people most of all.
Yeah, I have found that to be true. So I jumped in because we were talking about the changes.
Cannabis,
yes, right. And how important it is to bring dispositions to your attorney if you're looking at adjusting your status.
It was context of naturalization, yeah.
So I got that part right.
But cannabis is an important issue.
So
listen up.
So the issue is that any cannabis records, starting in January, it will no longer be illegal to
on the state level.
On the state level, right. But it remains, cannabis will remain a controlled substance federally. As part of Illinois' push to decriminalize cannabis, the state is also taking steps to rectify some of the wrongs that have come as a result of the policy. So it's good and it's thoughtful legislation, but one of the things that is happening is that the state is going to automatically be expunging people's records that would be eligible for expungement now that in Illinois it's not decriminalized, which causes an unintended consequence for immigrant communities, because once your record is expunged, it is theoretically possible to get the record from the clerk's office, but you're sort of at the mercy of the clerk's record-keeping practices, which I cannot characterize the risk for sure, but I would say that the advice that I've been hearing is that if you are thinking that you're going to want to adjust your citizenship status and you have cannabis charges in your background, you want to, as soon as you can, pick up certified dispositions of those charges so that you have the record when it comes time to talk to your attorney and figure out what your remedies are.
Right. Long story short, if you're coming in contact with the immigration system, don't get a cannabis record. It's a federal offense. It's a controlled substance violation. It may very well be a deportable offense. So just don't.
And the advice I was hearing was also not, if you have a cannabis card, don't carry it on your person. You want to make sure that you're being very careful, because even though this is becoming something that the state of Illinois doesn't care about, you still don't want to have. I mean, it would be problematic for somebody with.
Who's stopped for a traffic violation.
And somebody who's working in the cannabis industry that is going to be legal in Illinois, it will still federally be illegal. So
that's correct.
It's basically a shadow system of justice for people who don't have citizenship status, which is not awesome.
Right.
So.
Right.
It's funny because you were going through the stack of paper, and I guess there were some fee reductions, so there's a little bit of goodness in there.
Let's talk a little bit about domestic violence. Suppose I'm an abused woman. Where would I go what's the first thing I should do?
Well, a lot of people get directed to the domestic violence courthouse through the police. I guess I'm gonna make it even more complicated by saying that any good practitioner in the domestic violence field is not going to tell anybody who comes to them seeking help what steps they have to take. I think that it's a field where it really gets drilled into you that a person who is dealing with abuse is going to be the expert on their own safety and their own best options, and it can be very difficult to determine what the best course of action is. But a lot of my past work experience has been talking to people who have either come in contact with the police and have been told to go to the domestic violence courthouse, have been, have come in contact with DCFS and were therefore told that they have to go to the DV courthouse, or they need protection and they found out through other means that the courthouse exists.
And what happens at the courthouse?
So that's where you would petition for an order of protection, which is a civil order that tells the person who's been abusing you that they are no longer allowed to do certain things. So you would put in your petition what sorts of remedies, what sorts of responses you want the court to give you. It can be things like saying that they can't enter your home. If you live together, the order of protection can tell the person that they have to go stay someplace else, saying that they can't have contact with you, saying that they can't come to your work or to your children's school.
How does this work? Do I face the abuser if I'm going into court? How does it work?
Not typically the first day when you petition. It's called extraordinary relief because it is something that you would come to the court and you would petition the judge yourself without bringing the other side in. You don't have to provide notice to get an emergency order of protection, but what you do have to do is you have to give the paperwork to the sheriff to serve the other side so that they know about a future court date so that they can get a chance to come in. So
Do I need an attorney before I go in there, or do they have attorneys there to help me?
there are attorneys at, Ascend Justice has an office that's based at the Domestic Violence Courthouse. There are also other attorneys who take cases at the Domestic Violence Courthouse, but you do not need an attorney in order to file. So if you come to the courthouse and attorneys aren't available, the clerk's office is set up so that people can file the paperwork on their own. Like any other civil matter, you're allowed to represent yourself, and the court is designed to recognize the fact that most of the litigants are self-represented. It's open Monday through Friday. Typically, the doors open at 8:30 a.m. And I think that you can file all the way up till 4:30. At least that was the case when I was practicing there. So they have judges continuously hearing emergency orders when people come in to petition. The judge has to decide that there's enough reason to grant you the order for the time being, and then they'll give you another court date so the other side gets a chance to come in and answer to it. So they have to have built-in protection so that people can't come into the courthouse and just tell a story and get an order and then kick somebody out of the house and then that be the end of it.
We're going to be wrapping up pretty soon. So I want to tell you that there are legal remedies in the immigration context for survivors of domestic violence, one of which was the VAWA Act, which the purpose of the VAWA Act is to place an abused woman who is married to a lawful permanent resident or a U.S. citizen in the same position she would have been in had she married a person who was not an abuser. So if you are an undocumented person and you have been abused, you do need your orders of protection. You need proof, first of all, that it's a valid marriage, just like you would in any case, that it's a bona fide marriage. You need proof of the joint documents. You need proof that you've lived together, that you've perhaps had children together, that just the normal documents you would present to show that this is a bona fide marriage, and then you need proof of the abuse because you are petitioning for yourself. You are not relying upon the abuser to help you out. It's a remarkable, enlightened piece of legislation, and this remedy does exist and it does work. I've had a number of cases, and when a person who's been abused gets a green card, it is the start of a whole new life, a whole new outlook.
Is it possible to present other evidence if you don't get an order of protection as the basis to show that there was abuse? Like, can you show police reports or pictures of injuries?
Police reports are excellent, yes.
Okay.
But it's the total corroborative evidence taken together that persuades a person that there's been some abuse. And of course, the best evidence is if you've prosecuted the person criminally. So that kind of wraps it up for us. And we will be here on the third Wednesday of the month in January. So I wish you all a very happy holiday season, and thank you very much for watching. Thank you.
Thank you.